Can the death penalty be exacted on a mentally ill prisoner? Ford versus Wainwright takes up this question. After a murder conviction, Alvin Ford was sentenced to death. He was competent during trial and sentencing, but Ford's mental condition deteriorated while he awaited execution. Ford believed the Ku Klux Klan was conspiring to have him commit suicide. He was certain that his friends and relatives were being held hostage in the prison. He also began speaking in an incomprehensible code. Ford's psychiatrist diagnosed him with paranoid schizophrenia and concluded that the diagnosis left Ford unable to assist fully in the defense of his life. Ford subsequently saw another psychiatrist who concluded that Ford didn't understand why he was being executed. Ford's attorneys invoked Florida's procedure for determining the competency of a condemned inmate. Following the statutorily prescribed procedures, the governor appointed 3 psychiatrists to evaluate Ford. After spending 30 minutes with Ford, the psychiatrists each diagnosed him with a different mental condition, but all agreed that Ford was sane. The governor considered the psychiatrists' conclusions and signed a death warrant authorizing Ford's execution. Ford's attorneys argued that Ford wasn't competent for execution and unsuccessfully sought state court review. They then petitioned for habeas corpus in federal court, naming Louis Wainwright, a state corrections administrator, as defendant. The district court denied the petition without an evidentiary hearing. The 11th Circuit affirmed. Ford petitioned the Supreme Court for cert.